Alrighty, this is Deuce We the People News. Okay? I'm not an attorney, not giving legal advice. Just opinions only. Do not take it as legal advice. It's an educational video. Alrighty? We are trying to think outside the box. Never just look straight forward. Okay, so we're going to go back to old school ways. And remember, y'all, attorneys will not give you information. Okay? They want you to bank on them. And attorneys will not challenge judges, and judges will not challenge attorneys. They act like they do when they're in court. In one case, a matter, a couple weeks ago, I was just watching in court, my local courts, property taxes, right? So this guy paid money for an attorney to take care of his matter. And meanwhile, the county attorney was out taking property. Okay, now that being said, most people did not show up, so they stayed in silence acquiescence and it went into judgment. Okay, do not go into silence acquiescence, challenge the jurisdiction and all this kind of stuff. Now, the one that went up in there paid the money to kind of put it tax out of default, or not really default as court case, but past debt. Okay, now, issue I have at this time, and this is the reason why bar agreements are important. Learn it, all right, and then follow through with it. Make claims. Go after their insurance, people. We cannot have these rug attorneys. There's good ones out there somewhere. I haven't met them yet, but there's good ones out there somewhere. But the point being, the guy who showed up at court, that was on the stand, and that county attorney ran over the other attorney, and he just sit there and literally did nothing for this other guy that paid him. All right, and so the court, they got a summary judgment on the property. Well, the attorney left. The guy spoke to the attorney. They went back in. All right, they still had a summary judgment, but they made a compromise agreeing to do a 6-month payout list. But there's still a summary judgment, right? Just because they agreed to it, if it's not on paper, they agree to it, they can still confiscate the land and sell it before 6 months. So I just want to let you guys know that I talk about these things about attorneys, you know.
What are you doing, babe?
We're gonna save so much money. She looks so good. I decided
that
And
literally
how do you intend to react?
really just not on your side, right? This attorney literally let that other attorney run over him. There was no objections or anything like that. The other attorney was agreeing to all these terms instead of being on his behalf. So, you know, learn these things on your own and quit banking on these attorneys. And what I should have done is got out and try to get his name by maybe talking to the guy or whatever. Because I'm a witness, I could file a bar grievance on that attorney. But I was there for a different matter. And but I still should have done it because I seen criminal activities, right? The other attorney took advantage of the man's money that he forked out and did absolutely zero service for that man. Attorneys, get your frickin' act together.
By standing up?
Alright, this is going to be challenging like jurisdiction of the courts, which we talked about all the time, and lawyers out there, attorneys or whatever, they automatically have this, and this, even though the Supreme Court says anytime it's challenged that the courts must tell you. Must. Actually it says shall, but the Supreme Court says shall means must. So, must tell you. Quit listening to these attorneys and judges saying they don't have to. Alright.
For your rights, or being fearful and an easy target? During this proceeding, the judge will inform you of the charges against you and attempt to get you to enter a plea of guilty or not guilty. A third choice is no contest, which is essentially pleading guilty.
Now, on the bottom there, you'll see sovereignty. Okay? Now, understand this, y'all. Men and women are equal. We're all sovereign. We cannot rule over one another. So even though we're sovereign, we have no sovereignty over others. Okay? And this is what the courts are doing, right? And the government. They're tricking you. They're lying to you. They're misleading you. If you believe the government, I don't know what to tell y'all. Okay. Anyway, that being said, just because it says that, do not take it out of context of what you can actually do. Now, this is going to go in there and show you what you can do when you're in court. But remember, there's paperwork before and after. Mainly after, because of the simple fact, what? Municipal courts are crooked. Okay? They're putting you in a jurisdiction that you don't even belong. It's a business area. Business. They're operating in business. You broke some type of statute, policies, that you broke a business rule.
Without admitting guilt. Be careful, however, because as soon as you open your mouth to enter a plea, you have given them formal jurisdiction over you. If you intend to follow our procedure and win, you must not enter a plea. The judge's first question to you should be something to the effect of, do you understand the charges against you? Or it might be, how do you intend to plead? You must say no, you do not understand, or you cannot enter a plea until you get some questions answered. The judge will probably be irritated and try to intimidate you. You must politely state that you need to have some questions answered before you can enter your plea. Tell him that you do not understand the nature and cause of the action against you. Once the judge has agreed to answer your questions, your first question will be, is this going to be a civil action or a criminal action? In the highly unlikely chance that the judge answered your question by saying it is a civil action, your response will be, thank you, Your Honor. Let the record reflect that this is a civil action. Your Honor, since this is a civil action, I make a motion to dismiss for lack of a sworn complaint by an injured party and no injured party is present. More likely, the judge has stated that this is a criminal action, so you respond, thank you, Your Honor. Let the record of this court then show that this action against me is a criminal action. Now I have another question. Your Honor, the Constitution grants this court two different criminal jurisdictions. One is a criminal jurisdiction under the common law, and the other is a criminal jurisdiction under admiralty or military tribunal venue from Article 1, Section 8, Clause 17 of the Constitution. In which of these two criminal jurisdictions does the court intend to try me? Don't panic if you don't get the article, section, and clause. You'll have them down by the time you have practiced. But if you are afraid of getting it wrong, it would be wise to have some brief notes with that clause number in it. If the judge gives a specific answer, you will again say, thank you, Your Honor. Let the record of this court then show that this action against me is a criminal action under whichever jurisdiction he replied. However, don't expect an easy answer to that question, as you have just exposed the court's fraud. The truth is that they are acting under a military tribunal of which they have no right to use with you. But the judge can't say that. And he can't say common law, because if he does, you will make a motion to have the case dismissed because there is no sworn complaint by an injured party and no injured party present, exactly like he did if he said it was a civil action. When you protest that there is no injured party, if the judge is silly enough to say that the state of whatever state you're in is the injured...
Now, that being said, a military tribunal, whatever, okay? Maybe, maybe not. All right? But they're going after you because you broke a statute. All right? So you can use these little words to this section, right? Because it is in the Constitution. So you need to find out which jurisdiction they're trying to put you in. Okay? Most cases, this is based on tickets. Okay? So write this stuff down and just challenge them. Right? Remember, they're going to be crooked. The most likely chance are you're going to lose because they're crooked. Alright, they're putting you in a jurisdiction you do not belong because he says you're in a jurisdiction that he has no jurisdiction of. Just saying.
Party then say, Your Honor, I make a motion that this case be dismissed. We are in the wrong court. If the state is a party to the case, they cannot also be the judge and prosecutors. This case needs to be transferred to federal court or be dismissed. More likely, the judge will try to avoid answering and will tell you to get a licensed attorney for such legal advice. Your response will be, "Thank you, Your Honor, but I don't think you'd be violating your oath of office if you did your duty under the Constitution. You see, I am not seeking legal advice. What I want to know is legal intent. I have the right to appear as myself in my own person without a licensed attorney, and in order to intelligently defend myself, I have to know the jurisdiction that this court is operating under, because the rules of criminal procedure under a common law jurisdiction are very different from the rules of criminal procedure under an admiralty or military tribunal. I need to know under which jurisdiction you intend to try me in order for me to proceed with this case. The Sixth Amendment grants me the right to know the jurisdiction being applied, and it grants you the duty to inform me, and I don't think you'd be violating your oath of office for doing your duty. Therefore, will you please answer the question so this court is properly identified?"
We're going to pause there again because I want to clear something up. And I use it all the time, and I shouldn't, but I do just because of habit, right? And once again, we need to break habits. When you have a driver's license, we all call it contract. But really what it is a service agreement. It's not really contract. There's got to be men on both sides agreeing to the terms of the contract. What it is basically you signed a service agreement. You agreed to obey all these traffic rules, regulations, and all that, okay, to be left alone from officers. That way you didn't have to fight your constitutional rights. So you wanted the privilege and not to fight for the rights, right? But it's a service agreement. If you do this, you can do this, okay? That's what I consider this. Now, I'm not an attorney. I'm not giving legal advice, okay? It's just my opinion only, all right? Do your own research, okay? It's hearsay here, all right? But if you really mathematically figure it out, if it's not a man-to-man contract, it's a service agreement, okay? So, there you guys go.
If the judge still responds by telling you to get an attorney, your answer will be, "Thank you, Your Honor. Let the record of this court then show that I," your name here, "the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of the action. Furthermore, let the record also show that this court intends to bring this action against me under a secret jurisdiction known only to licensed attorneys." At this point, the judge might claim that this is a statutory jurisdiction under the statutes of the state of whatever state you're in. If he does so, your next statement is, "Thank you, Your Honor. Let the record of this court then show that it intends to conduct a criminal action against me under a statutory jurisdiction." But, Your Honor, that raises another question. I have never heard of such a thing as a criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution. I would be happy to accept this, Your Honor, if you could please tell me where I can find the published rules of criminal procedure under a statutory jurisdiction, and where this nature, cause, and jurisdiction information exists. It is imperative that I have the published rules of procedure so that I may conduct a fair defense and a fair trial. Now keep in mind the judge made up this jurisdiction. There is no granted authority for a statutory jurisdiction and no published rules. But don't expect him to tell you that. He must either lie, dismiss a case, or unlawfully enter a plea on your behalf. In rare cases, he might even threaten you with contempt of court. If he threatens contempt, say, "Your Honor, I do not wish to be held in contempt. I am simply trying to exercise my Sixth Amendment right that you disclose the nature and cause of the charges against me. I can provide court..."
Or just ask if it's a civil or criminal matter. Or you can extend what he says and add into that list as well. Or is this a civil or criminal contempt of court? Okay? Look at my past videos about the difference. Alright.
Citations that show that the exercise of a constitutional right cannot be converted into a crime. Please either identify the properly established jurisdiction, or I make a motion that you dismiss the case against me. Also unlikely, but still possible, is that the judge will tell the truth when you ask under which criminal jurisdiction you were being tried, and will tell you that it is an admiralty jurisdiction. If this happens, you would respond, "Thank you, Your Honor. Let the record of this court then show that this court intends to proceed with a criminal action against me, your name here, as a condition of contract under an admiralty jurisdiction as a military tribunal under Article 1, Section 8, Clause 17. However, Your Honor, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered into any international contracts, so I deny that any such contract exists. Will you please instruct the prosecuting attorney to inform this court if there is such a contract, and if so, to place it into evidence and explain how I am party to it and am compelled to perform under it? If the prosecution cannot do so, Your Honor, I make a motion that this case against me be dismissed." Of course, if at any time your case is dismissed, make your pronouncement. "Thank you, Your Honor. Let the record of this court reflect that case number blah 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 against your name here has been dismissed. Now leave quietly, save your gloating for outside of the courtroom." And if at any time you sense a good opportunity to make a motion for dismissal, make it, even if it wasn't part of your prepared script. You need to be flexible and jump on any opportunities that are presented to you. Let's say that the judge has had enough of your questions and decides to help you out by entering a plea of not guilty on your behalf. Immediately object. "Your Honor, I object. For you to enter a plea on my behalf is practicing law from the bench, because entering a plea is my job or my attorney's job. Has the court made a judicial determination that I am not guilty?" Now you've really trapped him. For him to say yes, he has admitted that you are not guilty. At this point state, "Thank you, Your Honor. Let the record of this court reflect that the judge has made a judicial determination that I am not guilty of the charges against me. Therefore, I make a motion that this case be dismissed because the judge has determined that I am not guilty." If he says no, he has not made a judicial determination, make a motion that the plea be withdrawn and you be allowed to enter your own plea once you know the nature and cause of the case pending against you. If the judge enters a plea of no contest, object, saying, "Your Honor, I object. For you to enter a plea on my behalf is practicing law from the bench, because entering a plea is my or my attorney's job. I make a motion that the plea be withdrawn. For you to make a judicial determination that I am entering a plea of no contest would result in the court treating me as though I had pled guilty. The court is trying to constrain me to an unfair plea choice in the absence of my understanding the nature and cause of the charges against me." Or let's say that the judge instead gives you a continuance and demands that you obtain a licensed attorney. Ask, "Has the court made a judicial determination to deny me the right to defend myself in my own person and to force me into hiring a licensed attorney that will conspire with the court to try me under a secret jurisdiction known only to the judge and the licensed attorney?" If you walk out of this hearing without a dismissal, go to Step 2, pretrial motions contained in your written packet. You should ask for a motions hearing, or you could ask to have the motions heard at the beginning of the trial. However, to ask for a motions hearing shows the judge that you are not willing to be railroaded so easily. Tell him that you must resolve some pivotal key issues in order to continue, and that these motions must be heard prior to a trial. At a motions hearing, you cannot be found guilty, but the case can be dismissed. Either way, when the motions are heard, they must each stand on their own and be heard and ruled separately from the rest. Don't just hand over 5 motions and let the judge say all are overruled. Make him rule on each one individually. Now let's take this from the top in the manner in which it will probably happen. Do you understand the charges against you? No, Your Honor, I don't. I need you to answer a couple of questions. I need to understand the nature and cause of the charges against me. Is this case going to be heard under a civil jurisdiction or a criminal jurisdiction? Criminal. Thank you, Your Honor. Let the record of this court then show that this action against me is a criminal action. Now I have another question. Your Honor, the Constitution grants this court 2 different criminal jurisdictions. One is a criminal jurisdiction under the common law, and the other is a criminal jurisdiction under admiralty or military tribunal venue from Article 1, Section 8, Clause 17 of the Constitution. In which of these 2 criminal jurisdictions does the court intend to try me? If you don't understand the law, you need to hire an attorney. Thank you, Your Honor. but I don't think you'd be violating your oath of office if you did your duty under the Constitution. You see, I am not seeking legal advice. What I want to know is legal intent. I have the right to appear as myself in my own person without a licensed attorney, and in order to intelligently defend myself, I have to know under which jurisdiction that this court is operating, because the rules of criminal procedure under a common law jurisdiction are very different from the rules of criminal procedure under an admiralty or military tribunal. I need to know under which jurisdiction you intend to try me in order for me to proceed with this case. The Sixth Amendment grants me the right to know the jurisdiction being applied, and it grants you the duty to inform me, and I don't think you'd be violating your oath of office for doing your duty. Therefore, will you please answer the question so this court is properly identified? This is a court under statutory jurisdictions and the laws of the state of whatever state you're in. Thank you, Your Honor. Let the record of this court then show that it intends to conduct a criminal action against me under a statutory jurisdiction. But, Your Honor, that raises another question. I have never heard of such a thing as a criminal action under statutory jurisdiction, and there is no such reference in the Constitution. I would be happy to accept this, Your Honor, if you could please tell me where I can find the published rules of criminal procedure under a statutory jurisdiction, and where this nature, cause, and jurisdiction information exist. It is imperative that I have the published rules of procedure so that I may conduct a fair defense in a fair trial. Look, I'm just going to enter a plea on your behalf and set a trial date. I enter a plea of no contest. Your Honor, I object. For you to enter a plea on my behalf is practicing law from the bench, because offering a plea is my or my attorney's job. For you to make a judicial determination that I am entering a plea of no contest would result in the court treating me as though I had pled guilty. The court is trying to constrain me to an unfair plea choice in the absence of my understanding the nature and cause of the charges against me. I make a motion that the plea be withdrawn and this case be dismissed because the court has failed to identify a legitimate jurisdiction. I deny that motion. Your trial date will be such and such a date. Your Honor, I would like to request that we set a motions hearing prior to the trial date, as I must resolve some pivotal key issues in order to continue, and these motions must be heard prior to the trial so that I can properly defend myself.
All right. Let's get that. Okay. So, anyway, there you guys go. There's a start, right? And remember this, y'all. It's better just to pay the ticket if you do not want to consist of fighting, okay? Because it's a pretty lengthy process. Most people much prefer waiving their rights than standing on them because they just don't have the time and trouble to do so, okay? And I, for one, understand this. However, you know, if you want to proceed forward and stand on your rights, then you must stand all the way, okay? And if you can get any type of record, like this case here, right? Pay an extra money, have a, what do you call them people? You know, it kind of goes, sits there beside the judge and types everything up. The one you pay for sits beside you. Go through that paperwork, pay for it, decipher what was said through the process. One thing that we're not learning and nobody's actually telling us is, number one, file a district complaint on the judge. What that judge was doing in this case was acting dishonor under commercial codes. Okay? Again, it's not legal advice. It's just my opinion, so do not take it as legal advice. All right? But you can still challenge it. And you can still put a judicial complaint in there. A bar grievance against the attorney that raised the issue. Right? Now, you're going to have to do a couple of steps. Number one, you're going to have to follow with the bar. Number two, they're trapping you into some unknown jurisdiction, which is committing a crime against you. So you may want to put a criminal deal in there. Okay? Other videos on that other times. Learn how to file a judicial complaint and a bar grievance, and learn how to make claims on these attorneys, because they're going to throw it in the trash. The only way it's going to stand is if you actually file some type of suit, some type of claim. All right, you guys call it a suit. I call it a claim. Either or. Okay? Just depends how you want to do this. But it gets the insurance to recognize and force the attorney or judges to tell the insurance company what they are doing. That's what we want to do. We want the insurance to recognize this. Now, just like any type of speeding ticket, your insurance goes up. Their insurance goes up too. Anytime, there may be a follow-up court date on this one particular judge. You file another judicial complaint. Boom, boom, boom. Next thing you know, there's 5 or 6. Boom. That insurance is going, whoa, wait a minute here, y'all. This is getting out of hand. Alright? Just again, it's not a legal advice. Okay? It's just my opinion. Okay? Take it as you wish. Okay? There you guys go. I know this video is a little long and I stretched it out. Sorry about that. These are We the People News. Till next time. Bye, y'all.